And welcome to the Week 1 and Week 2 video lecture. Both Week 1 and Week 2 are going to be involved with Chapter 1, having to do with the complaint. The complaint is the first thing that needs to be filed before a court will take control or take jurisdiction over a particular case. Without a written complaint filed with the court, and of course the filing fee paid and all that sort of stuff, you don't have a case. There is nothing that the court will take notice of because it doesn't exist as far as they're concerned. So we'll see that the complaint is a very important aspect of civil litigation, because without it we don't have civil litigation at all. And it's the fundamental starting point with which the entire case will begin. All right, so let's get right into it and see where we're going. First, we're going to get into the complaint itself and also the appearance by the plaintiff. And essentially that's what a complaint is. It's a way that the plaintiff comes into court and makes an official appearance. And it is the document by which they say, I think something wrong happened here, and I think the defendant owes me something, and so I want the court to enforce whatever law allows me to enforce some sort of remedy for whatever has happened. In civil litigation, it's always about remedies. It's always about trying to make the plaintiff whole after some bad thing has happened, either a tort or a violation of a contract or something of that sort. Then later on, in the class, we're going to get into filing, service, calendaring, and taking a default, because once the complaint is filed, then we have to serve it. We have to calendar many dates specifically with regard to the complaint and its service, and when the response is due. But within a certain period of time, if a plaintiff files a complaint, serves it by personal service on the defendant, then there's a limited time in which to file a response on the part of the defendant. Or if they don't, then their default will be taken. Judgment will essentially be entered in favor of the plaintiff. And then it's all then a matter of going to court to figure out how many dollars are owed, rather than whether the defendant owes anything to the plaintiff. We'll also look at, in the next chapter after going through the filing, service, calendaring, and taking of the default, we're going to get into the appearance by the defendant. How does a defendant appear in the action so as to defend themselves? Essentially, they have to come in. They have to file a written document, just like a plaintiff has to file a complaint. Well, the defendant also has to file a written response to the complaint in some fashion, and we'll see there's lots of different ways they can respond. But they have to do so within that limited period of time, or their default will be taken. And then we'll go at it from that point of view and discover the several ways that defendants can answer or otherwise appear in the action, so that they can be counted essentially as someone who wants to defend themselves. And then we'll be looking into, after appearance by the defendant, we'll look into discovery, which is that process by which, in civil litigation especially, there are many legal tools that are given to us to allow us to essentially collect evidence for our case, either from the opposing party or from third parties, even those unassociated with the case at all. And we can gather that evidence through these legal compulsions that we have, through these legal tools that give us the right to compel people to give us evidence, whether they like it or not. So there's lots of them. There's the depositions, interrogatories, requests for admissions, inspection demands, and if people don't like to give us things that they're supposed to, we can make motions to compel further answers to any of those devices that we've talked about, and we can also exchange expert witness information. We'll go through all that as part of later chapters and later weeks in the class. Then we'll get into motions. Motions are essentially a request for the a court to make an order. If you think about civil litigation, except during the actual trial itself, all civil litigation is happening pretty much entirely between the parties involved and has nothing to do with the court. The court's not there. There's no judge watching over what's going on. It's sort of like playing a basketball game with no referee there. But we have a videotape going and watching everything that's going on in the game. And if someone cries foul and the other side says, no, you didn't, I didn't foul anybody, then they can take the videotape into court and say, hey, judge, I was fouled. Here's the videotape that shows I was fouled. Now I want you to make an order giving me a remedy for this foul that was committed by the other side. And so order them to do what they're supposed to do. And so that's what a motion is. It's a way for the judge to get into a case when a judge is needed to resolve things so that the law is enforced against the parties and everyone gets what they're entitled to under the law. And then the next area we'll get into in the class is pretrial matters. There are many matters that happen just generally between the last 3 months before trial. There are settlement conferences. There are a number of matters that have to be taken care of. Discovery will start ending around that time. And if we want to file any motions regarding discovery, we'll have to file them generally within that 3-month period, or actually within a month of the trial. They have to be decided. And then there's lots of other matters we'll go into, but those are important aspects of the trial, because if these pretrial matters are not taken care of, you're going to walk into trial and things will not have been taken care of that needed to be taken care of, and you can't take care of them in trial. And so you're just going to lose. So you may lose all sorts of discovery that you could have had. You might be blindsided when you get into trial because there's things you should have known about the case you didn't know, and there's no way for you now to question the evidence that's being put against you because you didn't look at it before trial and get a chance to figure out whether it was truthful or not, and that sort of thing. Also, settlement dismissal. We'll look at that as a very special area for many different aspects of both the law and of practical resolution of the case short of a trial. And then we'll go into judgment and enforcement, assuming that we've gone to trial and or we've settled the case and we have a judgment now. How are we going to enforce it? So that's basically where we're going to go in the course. So you can see that we start out with the complaint. We go for filing, service, calendaring, and taking default. Then if the defendant appears, we deal with the appearance of the defendant. Once the defendant has appeared, then we have the case at issue. That means it's ready to go, not quite ready to go to trial, but at least it's set up in terms of all the issues between the parties that have been set out in writing. All the issues that the defendant has against the plaintiff has against the defendant is all there in writing. And then it goes into the discovery phase, where we try to collect all the evidence that we need, both from the other side and from third parties, to put our case together so we actually have a case, because we don't always have a case. Sometimes we have to get documents from the other side. Sometimes we have to subpoena documents from third parties. Sometimes we have to ask questions of the defendant to see whether we can get responses, to see whether they know something that we need to know, and that sort of thing. But the discovery process is generally looked upon favorably by the courts because they want both sides to be able to get that evidence together so then they can figure out whether they have a case or not, and then whether they should settle the case prior to a trial. Then the motions, of course, are just part of the process, both in terms of discovery motions and motions that are not related to discovery. But we'll go into those, of course, as we said, and then pretrial matters, settlement, dismissal, and then judgment and enforcement. By that time, we're sort of done with the trial aspect of the civil litigation. Beyond that, of course, the only thing left for that would be an appeal. And we'll go a little bit into that, but not very much, because that's a specialized area that we don't need to know so much about, generally speaking. All right, so let's continue on with the complaint. Let's get into the specifics of the complaint. First thing before we ever file a complaint is of course, we're going to have probably a client interview to figure out what's going on. A client comes in and says, something wrong happened and I want to know whether they have any legal rights. And then you go through and you look at what happened as much as you can. You determine as many facts and circumstances as you can to see what may have happened here. And then you go research the law and you see whether you have a meritorious case for the plaintiff. And of course, somebody can come in, by the way, who says, I think I did something wrong. At least these other people think I did. And so they're coming after me and they're saying they're going to sue me and so on and so forth. Well, you want to do the same thing. You want to figure out what went on, what really happened, as best you can at that stage. And then research the law, see whether there is, in fact, a good case against your client or not. And if there is a good case against your client, then you will want to, decide on what to do at that point. Are you going to try to settle it before they even file the case, or are you going to try to go ahead and let them file the case and go through discovery and go through a trial, that sort of thing. But you have to figure out whether there are merits to the defense, just as much as you want to file whether there's merits to the case against a defendant. Either side, it doesn't make any difference. But the first thing we always want to know is what are the merits of the case that we have for our client, whether it's plaintiff or defendant. Then we want to get impressions about our client. Sometimes clients are not particularly truthful with us. We'd like to think that they are. They're supposed to be, because we give them a privilege so they don't have to worry about it. If they say things that were bad about what they may have done, it's not going anywhere. But not even so, the clients will sometimes not give us the best information. And sometimes we see that our client isn't the most sympathetic character out there, or things that juries are going to pick up on. We want to figure out whether not only do they have a case, but does it look like they are someone who really should have justice in the case. That's just something we look at, because if we don't, we're going to be selling our client short by not taking that into consideration when deciding on whether to file a case or to mount a defense. Then we look for conflicts of interest. We got to make sure that if we are suing somebody, or we're on the opposite side of someone, that whoever that someone is not someone that we've ever represented as a law firm in the past, because if we did, we're precluded from ever going against them. Again, you can't go against a former client or present client, no matter what. You can never take an adverse position against them. And so you check to make sure that no one on the other side is going to be in that conflict of interest position. And then, of course, we're going to ask whether the case is compatible with our firm's expertise and goals. Do we really want this case? First and foremost, we want to ask ourselves is, can we make any money on the case? If we cannot, then we're probably not going to take it unless we feel like we want to do some pro bono work and help somebody out because they need it, and we just don't care so much about money. And that happens probably it happens whether you like it or not, because not everyone pays you as an attorney. Sometimes you take a case because it's just the right thing to do, even if money isn't going to be coming from the case. And we also want to know, do we have the expertise to do the job? And also, do we have the resources to do the job? Who's going to be on the other side? What kind of case do they have? How complex is the litigation? How much time are we going to put into this case to get the result that we would want to get, and that sort of thing. And then we will also want to know whether the case is subject to mandatory arbitration. It's possible that this case may have been involved in people who have had contractual relationships before, and there is a contract between the parties that provides that if there is any dispute, it must be sent to mandatory arbitration rather than go through the court system. And that'll be an important aspect of whether we will take the case or not, because mandatory arbitration is a different world than the jury trial civil case. It's done with judges that are usually the attorneys. It can be somewhat expensive, but not much more than the court proceedings, but it's also much more informal. Usually happens much quicker, and so we have less time to get ready. So we've got to take all this stuff into consideration to decide whether we're going to take the case at all, and then whether the client has a case, and we have to give them good advice on whether they have one. And then we'd have to get a retainer agreement if they're going to take a case, whether it's on the defense or plaintiff. In California, it's required if the amount that's going to ever be charged is more than $1,000. And I guarantee you, if we're taking a litigation case, it's going to be more than $1,000, no matter what. I don't care what kind of case it is. Even a small landlord-tenant eviction would be a lot more than $1,000 these days. Okay, so pre-litigation planning is we got to figure out first what kind of causes of action are supported. Now, causes of action are the same thing as criminal counts that you see in a criminal case. A criminal count is we claim a certain violation of a certain law. We could say somebody was guilty of domestic violence. They were guilty of vandalism. They were guilty of trying to outrun a police officer. These are all separate counts or separate violations of the law. Well, in the civil world, we call these same things causes of action. It means reasons to sue. So whenever you hear the word cause of action, that means that's a reason to sue. So there generally are many reasons to sue. We could have a breach of contract case, but it could also involve fraud. So we could have a tort claim for fraud as well as a breach of contract cause of action. These are separate causes of action, each one based on different laws and each one requiring different proof. So that's the first thing we want to figure out is what kind of causes of action are supported in this case. And that's either because we have the plaintiff or the defendant, because if we are on the defense side, we want to know what kind of causes of action are going to come after our client so we can see what kind of defenses we might have to those causes of action. We also want to know very quickly is what kind of statute of limitations we may have. And that often has to do with what kind of causes of actions we have, because each cause of action may generally have a different statute of limitation. It may also be important as to where the cause of action accrued. Where did it start? Where did the action happen that resulted in the cause of action? So if it's a tort, for instance, and it happened in Nevada, we may find out that we may not have jurisdiction in California, and we have a different statute of limitation in Nevada than we have in California. So we may be very much aware that where our cause of action took place may have a very big implication as to what statute of limitations we might have as well. First, then we want to know who should be sued, especially if we're the plaintiff. But we also want to know that even if we're on the defense side, because there may be people who are required to indemnify us, and so we may have to sue them as a defendant and bring them into the action so that they can be a judgment can be entered against them as well as us if the worst happens. Also, where do we want to sue? That's a very important question. Sometimes we have more than one place that we can sue. Sometimes we can sue in state courts. Sometimes we can sue in federal court. Sometimes we can sue in several different state courts, depending upon what may have transpired or where the people where they live. So it's a big consideration. It may be that we can't take the case because it really should be filed in Nevada, for instance, and we don't practice law in Nevada. That's an important consideration. These are all pre-litigation planning aspects to figure out what we're going to do. And then the next question is, especially if you're the plaintiff, what kind of relief should we ask for? If we were wronged in some way, we're going to have to ask for a specific amount of a recovery for the wrong that was taking place. We don't have to give them specific dollar amounts when we file our complaint, but we should think about how many dollars is this case worth. So, for instance, if the case is worth $10,000, we might tell our client, listen, you're going to spend more than $10,000 on taking this into court. And so, you might think about whether you really want us to take this case. You might want to take it to small claims court, which has a $10,000 limitation. Do it yourself, and take your chances, because you will spend all that money and more, bringing us into this action. And also, we wonder if we could do some informal discovery to evaluate the case before we actually either file it or decide on a defense. It's possible we could go to the other side and say, hey, you say there was this contract, and you say our client signed it. Could we take a look at this contract? Because our client says he didn't sign any contract. Could we take a look at the contract and see whether that's really our client's signature, or whether maybe there's a forgery or something going on here? That might be something like a request for informal discovery. And this is give us that thing and let us look at it, because, we need to know whether we really have a problem here or not. That would be a good example of this pre-litigation planning. Also, sources of information for evaluation. First, one of your sources is going to be your client, one way or another. They know something about the case, and they will give you some information. But there also will be third parties. These could be either lay witnesses. These are people who witness something that we need to know about, one way or the other, good, bad, or indifferent. And we may also have to retain expert witnesses if there's some technical aspect of the case that needs to be brought to the jury's attention and evaluated, such as we may have an auto accident case, and it's a 20-car pileup, and we really don't know from all the information that's been gathered about what happened, exactly how the accident happened, but we know that an accident reconstruction expert might be able to tell us how it happened, and so we may have to retain that expert to figure out whether we have a case or not. We also can get information from the opposing party. We could call them up and say, hey, what's going on here? Tell us what your position is, or what do you think happened? And maybe they'll cooperate with us, maybe they won't, but they may cooperate with us, and if they do, they'll probably give us some information. They might want to. They may want us to settle this thing without having to go to trial, because they don't want to spend attorney's fees either. Also, documents and physical evidence. We might have documents out there and physical evidence that we can pick up. If let's assume there was an accident and we jump on it real quick, we might find evidence at the scene. We might be able to still have the car that was totaled that's in the impound yard. We might be able to get our hands on that as a piece of physical evidence, because that might tell us how the accident happened. You'd be surprised how these new cars store information about usually the last 30 seconds before an accident. They store basically everything that was going on in that vehicle up until the 30 seconds before it stops, and that's saved information. If we download it, we can figure out exactly what was going on with the car. We can tell when the person slammed on the brakes. We can tell you what speed he was when he first put the brake on, and so on and so forth. It's just amazing stuff. But that piece of physical evidence could be extremely important. Now, let's also look at what's called standing to sue, which is a concept that is kind of important. It's something you usually don't have too much problem with, but occasionally you do. we have to ask ourselves, is our client the person who is allowed to sue under law for whatever loss may have occurred? And a good example of that is a wrongful death action. If there's a wrongful death, only certain people are allowed to sue. I'm not sure if it's changed yet, but unless let's say a same-sex marriage couple is actually married, the death of one of them is not considered a loss to the other because they're not married. If they are married, then that's different. Then being married is a recognized loss when you have a death of the spouse, whether it's a same-sex marriage or not. And so you have a right to sue for a wrongful death of your spouse. You may also be able to sue for wrongful death of your child. A child may, depending upon how old they are, be able to sue for the wrongful death of their parent. It all depends on state law as to who can sue for certain types of losses. And so we have to look at that sometimes because it's not always clear. I remember my wife, for instance, had where her parent was wrongfully killed, and the question became whether or not she had a right to sue, and we had to research the law to see whether she had a right to sue because she was no longer supported by her father, not for many years, and yes, it's a death of a close family member, but the law doesn't always recognize what you think they might recognize in terms of who loses when certain bad things happen. Next is a capacity requirement. This only has to do with times when people don't have the capacity to sue in some cases. For instance, minors cannot sue in their own name. They have to have a guardian ad litem appointed. Basically, usually it's their parent that's appointed to prosecute their case. And so it's the guardian ad litem for the minor that sues, not the minor themselves. Corporations that are suspended are not allowed to sue, although they can sue if they are not suspended. And if they have right to do business in its particular state, then they can sue within that state. And executors will sue for the estates of someone who has died. So you may have a cause of action, but unfortunately you die before it's ever brought to court. Well, your executor then can bring it in because they represent you as your estate. So in essence, when you die, your estate doesn't just disappear; it just becomes controlled by someone else, and they can go in and sue for you. It's also true that in order to have capacity to sue, and if you're suing for something that required you to have a license and you don't have that license, you're not allowed to sue. A good example of that is if you are a contractor and you contract for a $5,000 job and you don't have a license, you will not be allowed to sue. It's a public policy reason. You are required to have the license for many good and very important reasons, including the fact that you have to have a bond to indemnify anybody in case you don't do a good job. And because of so many abuses that have happened with people who are unlicensed, they require licenses. And so if you're going to decide to do work as a contractor without a license, then you're not going to be allowed to sue if you get stiffed for the money. If people don't pay you, too bad. That's your problem. That's a public policy decision. It's part of the statute. And of course, another one is fugitives from justice. They cannot sue either. And that's just because if you're going to be a fugitive from the law, you're not going to be allowed to use the law. So you got to turn yourself in if you want to sue, if you have a warrant out for your arrest. Okay, let's look at DOE defendants because it's an interesting topic. What happens if you're suing someone and you sort of know there's a chance that other people might be liable to you, but you don't know who they are? Let me give you a good example. You were involved in an auto accident, and you know the name of the person who was the driver of the other car who caused the accident. You know the license plate of the car that caused the accident, but you don't know who owned the car. You don't know if it may have been negligently entrusted to this person. Let's say, some mother lets an adult son go out and use a car when they've had 12 DUIs and they killed someone in several different accidents, and so on. And they entrusted their car to this person. Then beyond the fact that they have to pay the minimum insurance amount, they may have to pay the entire bill for whatever the losses are as well if they negligently entrusted their car. But you didn't know that when you sued this person, and it took time to figure it out. So what we do is, instead of sort of losing control over these people who we don't know who they are yet, we allow you to sue, in California anyway, sue people in the lawsuit under a Doe name, which is just a fictitious name for people. And these are people alleged in the complaint to be people who owe you in some fashion, but you don't know why, not at least at this point. And then you simply say that you will amend the complaint to add their names in when they're ascertained. And that's just a way to allow us to bring in people who we didn't know about initially, but find out about later. And so we will often, in our complaints in California, under state law, add in anywhere from 1 to up to 100 or more Doe defendants, so that it's possible that we could later name up to 100 extra people in the lawsuit who may owe us money that we didn't know about initially. So there's sort of like a placeholder for parties who are currently unknown. And so we can also possibly use them if we use the wrong name for someone. Let's say we didn't realize that someone's name has changed. Perhaps they got married and they changed their name, or they may actually have legally changed their name, but we sue them under their old name. We can actually correct that by amending the complaint to add their correct names as a Doe defendant. And what this does is it relates back to the day the original complaint was filed, so that by adding their names in and adding them into the lawsuit doesn't mean that we're going to be out on the statute of limitations, because we're allowed to go back to the day we filed our original complaint, even if that person was never named in that complaint, so long as we name these Doe defendants. So it's something we do routinely in our complaints in California, as we added in several Doe defendants just to make sure that in case there is anybody out there that we didn't know about, we can add them in later. All right, there's another important concept called compulsory joinder. Some parties, you're required to join them in the action. You actually have to bring them in between, you have a plaintiff, you have a defendant, but you got to bring somebody else in. There's lots of examples of that in Chapter 5 of your textbook, but it's possible that without that person, you can't actually get a judgment, proper judgment anyway. And so you have to bring them in. So if you don't have that person, you can't order them to do something. And that's as if the court doesn't have them in the action as a party, it cannot order them to do something or not. Let's assume, for instance, that you have a pension program and you're going through a divorce. The pension's owned by some government agency that you work for, but you're going to have to split the pension between you and your spouse. Well, you would like to have an order that tells this government agency to now split the pension half and half, so that each party gets their own half, rather than you hoping that your other spouse, when they get paid their pension, pays you half of it like they're supposed to. And so what you'd have to do is you have to bring in the government agency as a party. That would be a compulsory joinder. If you want the order against the government agency, you have to bring them in as a party under this compulsory joinder. And then the court can grant the relief by ordering that party to split the pension in two, and each party gets their half directly from the government agency, rather than hoping that one party does the right thing and gives their half to the other side when they get the whole bit of the pension. If the party has an interest in the action that has to be protected, it's another reason for compulsory joinder. So it's possible, for instance, you could have an insurance policy, and the owner of the policy is suing the insurance company for not having paid off, and but the beneficiary of the policy is not there. Well, that person has an interest in the action, and it's got to be protected, because they're the ones that are going to get paid the insurance. Let's say it's life insurance. And let's assume you died, but your estate now is going after the insurance company for not paying the beneficiary. Well, you better have that beneficiary in there also, because they have an interest in the action. It has to be protected. And so you'll have a compulsory joinder to actually join them in, if they're not already. It's also required if the party's absence can expose other party to further litigation. In essence, if it just happens to be that if we don't get another party in there, we're going to end up with a second trial against them, then it's compulsory. It means you have to bring them in. If you don't, then the court will dismiss your case and make you do it again. If you want to come back in, you're going to have to join them in. All right, there's also permissive joinder. That means we can bring people in certain cases if we want to. and there has to be some legal or factual relationship between the parties that makes it sensible for them to be joined in some way. If there is, then a court can by what's called permissive joinder join them in. It just makes sense often when it'll prevent a second trial especially. Okay, let's go on to where do we sue. There's a couple questions about that. It's not only what jurisdiction do we sue in, but also within that jurisdiction where we sue is also important. It's called venue. I'll talk about it in just a second. Subject matter jurisdiction means does the court that we want to file in have what we call subject matter jurisdiction? It means that they have jurisdiction over the subject matter of our case. Let's assume we have an auto accident. It happened in California. Well, then the California courts have subject matter jurisdiction over that accident because it happened within their state. And anything that happens within the state can be adjudicated in a state court, except for a few areas of exclusive federal jurisdiction, like patents, copyrights, trademarks. That sort of thing has to be adjudicated only in federal court. But then, other than a very, very small amount of exclusive federal jurisdiction, state courts can hear any matter about anything that happens within their territorial borders. And so we would want to ask that question: where was this accident? Where did it occur? Now, sometimes though we have transactions where it happens in several states. We may have contracts that were between parties in many different states. It may have performance that was required in many different states. Then it's possible that we may have subject matter jurisdiction in many different states. Quite possible. So which is the best place to sue might be a very important question. We might win in one case because the laws are in our favor in that state, and lose in another because they're against us in another state. It's quite possible. So we've got to figure that out. It's kind of an important question, and it's not something we want to just short off and just go for the easy answer, because sometimes if we get outside of one state to another, we can win a case, whereas we might just totally lose it if we file a case in our local court. All right, but let's assume we have a case in California for an accident that happened in California. Well, then we have to figure out what court within California do we sue. Well, you're going to sue within the county superior court where the accident happened. There's very little reason why you would be able to sue anywhere else if the accident happened there. Now, if it happens to be that the defendant may live in San Diego, for instance, and let's assume it's a breach of contract cause of action, then we're probably going to have to sue in the San Diego County rather than where we may live up here, let's say in Santa Barbara County or San Luis Obispo County or Ventura County. We sue where it is appropriate to sue based on lots of rules of what we call venue. So where's the venue within the jurisdiction? Jurisdiction is whether or not the court system itself you're filing in has the legal right to allow you to sue. And then if you do have the legal right to sue within that jurisdiction, then where within the jurisdiction do you sue? And that's called venue. All right, so also there's personal jurisdiction. We have a court has jurisdiction over any person who lives in their territorial jurisdiction. Meaning California has the right to adjudicate any case against a person who happens to live in California. And so that's the reason why, for instance, that if we have a transaction between us in California and a person in New York via eBay, for instance, we can always sue in New York for our defendant because the New York courts have personal jurisdiction over that New York resident. California doesn't have jurisdiction over the New York resident, but New York does. California court jurisdiction is, again, anything that happened within the territorial boundaries of California is something that California courts, that state courts, have jurisdiction over. Federal courts, though, have jurisdiction over certain areas called first exclusive jurisdiction areas, which is the patents, copyrights, admiralty law, bankruptcy, and a few others, military law, that sort of thing. It's all exclusively federal jurisdiction. You have to be in federal court to hear those kind of cases. It's just part of our Constitution, where those types of cases were said to go only to federal courts no matter what. So state courts do not have jurisdiction over those kinds of cases. But it's also true that we could have a case that happened in California that perhaps could be filed in California state courts because it happened in California. Could also be filed in federal courts if certain things are true. One of them is if the case involves a question of federal law in any way, then the federal courts have jurisdiction over that case, that civil case. Okay, we're not talking about criminal cases, because in criminal cases, it's only the state. If the state's the plaintiff in a criminal case, then only the state courts can hear it. If the United States of America is the plaintiff in a criminal case, then it's only the federal courts that can hear that. But for civil cases, if the civil case involves a federal question, so let's assume we have a dispute with someone over a television license, a license to a television station. The rules about how television licenses can be transferred is federal law. It's under the Federal Communications Commission. And so if any of that law about the Federal Communications Commission is going to get into this case in some fashion, then we can take that case to federal court because it involves a question of federal law. Also, we can get into federal court if we have what's called diversity jurisdiction. That means that if we have what would otherwise be a state court case, but we have plaintiffs and defendants that reside in different states, and there's at least $75,000 in controversy, then we have what's called federal diversity jurisdiction, and you can go to federal court in that event. But they will still be applying state law regardless, and they will be adjudicating the case pretty much exactly the same as they would in a state court. But it is one that can be filed in federal court, and it's nice because federal courts have nationwide jurisdiction, and so they can, your subpoenas can easily be served anywhere in the United States. There's lots of advantages to federal courts, but we don't always use them. We'd use them in some cases. It's all based on tactical considerations, but we can't get into federal court if we don't have either federal exclusive jurisdiction, federal question jurisdiction, or federal diversity jurisdiction. If we don't have one of those, we will not get our civil case into federal court no matter what. Now, there's this thing called forum nonconveniens, which is it's a Latin expression. It simply means that it's an inconvenient forum. It's possible you could file in a state court, and they have jurisdiction. That means they have the legal right to adjudicate the matter, but it happens to be that all the witnesses, let's say, or say 90% of the witnesses are from another state, especially if they're across the country. And the only person who's even involved in this case in our court that we've filed in is one person. It's likely that this one court that has this one person that's lives in their jurisdiction might very well say, you know what, we're going to give up jurisdiction of this case to another court because this is a non-convenient forum. We want to have this case heard where it's more convenient for the parties. And so sometimes cases can be sent to other states because of that, the fact that it's not a convenient forum. All right, let's look at personal jurisdiction. The first is in personam jurisdiction, which is just a Latin phrase. It means in person, in the person. In essence, we have jurisdiction over the person. So any state who has someone who either lives there or who is within their territorial borders at any given moment, that state has jurisdiction over that person. So if someone's traveling through your state, for instance, they can be hit with being sued in those states just because they're in there, even if they're traveling through the state. It's because they happen to be a person who's within their jurisdiction because they were traveling through. So the court has jurisdiction because they happen to be there. You have to think about jurisdiction as being sort of an old and antiquated concept, because in today's world we travel between states without even thinking about it, even between countries, but barely thinking about it. But back in the times when jurisdiction was first brought out as a legal concept, it was very difficult for people to travel very far at all, and often didn't at all. And so, the country had jurisdiction over a particular person because they lived there. And if they lived there, then it wasn't any doubt that the court had jurisdiction over them because they lived there. Now, it's a different world because people come and go all the time. It's hard to even tell sometimes where people live, especially if they have more than one home in more than one state. Where exactly is your home when you have 3 or 4 homes in 3 or 4 different states and you don't even have any plan about where you're going to be the next night? Kind of a tough one. It's just that we have to follow these rules until they get changed. And they will change over time because they're not working very well now in some respects, and they often give us some trouble because they're such antiquated concepts, but we still have to go along with it anyway. In any event, a state court or even a federal court has jurisdiction over any person who happens to be within their territorial jurisdiction. So California, for instance, territory of California is everywhere within the state and even 3 miles out into the ocean. That's California territorial jurisdiction. Also, in rem jurisdiction is, in rem simply means of the thing. So, for instance, it's possible that we may have a ship in one of our harbors. The ship itself is a thing. We may not have jurisdiction over the people who own the ship because maybe they live in Syria, for instance, and they have no citizenship in the United States, they have nothing to do with the United States, and they own the ship. We can't sue them in California state court or even in federal court because they're not citizens of the United States, and neither the United States nor California has jurisdiction over them. But because the ship is in our harbor, we do have jurisdiction over the ship. So, for instance, we could bring an in rem case against the ship and adjudicate the case against the people who owe us the money, and then we can take the ship as a way of getting remedy. So we can actually bring an in rem action against the ship to pay for what it was owed because the ship did something, or some people on the ship did something wrong, or the ship collided with some other ship, or whatever may have been the reason why somebody owes us some money. Then there's quasi in rem, which are similar. It's just a very similar jurisdiction. And we have the long arm statute. The long arm statute simply gives us the ability to go a little bit further than our jurisdiction in some situations. So, for instance, the long arm statute says in a breach of contract case, we have jurisdiction over everyone who either signs a contract in California, everyone who agrees to a contract whose performance was to take place in California, or comes into California to sign the contract. If any of those things are true, then we have jurisdiction over someone who might not be a citizen of California and may not actually be in the state. But if the contract calls for performance of the contract in the state of California, then we have jurisdiction over them. So there's lots of long-arm statutes in terms of it gives us a little extension beyond our territorial jurisdiction. And there have been many cases where things have happened outside of the state of California, but they have direct impact inside the state of California. And a good example of that was one I had where harassing phone calls were coming in from New York into California, and the California court believed they had jurisdiction over the New York resident who had never even been in California and never was going to come into California. But they got a warrant for his arrest, got the New York courts to sanction the warrant. The warrant was picked up. He was brought into California and tried on a harassing phone call case, and that was where the state of California was exercising jurisdiction over someone who wasn't even a resident and hadn't physically done anything in California, but he had had an effect in California. So the long-arm statute will allow those kind of things to occur. So think about it, if someone is in Arizona lobbing bombs into the state of California, we can go after them even though they have no contact with California. All right, let's look at the pleading. Pleading is an old word, old English word, and it meant you used to go to court and you would plead to the Lord for justice. And you would plead as if it's on His mercy that He would give you justice. Because of those old words that we've had in the Old English word, we still talk about a complaint as being a pleading. It is something where we're pleading for justice, even though the word doesn't have the same meaning anymore. We don't plead for justice when we go to court. We demand it. We demand that the court enforce the law and that we be given a remedy, politely, of course, but we do demand it because the law says we have a right to it. We don't say that, well, Judge, would you please give us justice? It's no, Judge, you must give us justice. So it's just an old word, but that's the reason why it's there, is because the Old English way of talking and who it was who was giving out justice way back when, 1,000 years ago, that we still have that word hanging around. But a complaint is a pleading. Also, an answer to the complaint is a pleading. An answer is something filed by the defendant. That's a pleading. And so we call it by a generic term, it is a pleading. But it's where you're asking for relief from the court. So a complaint, you're asking for relief. You're saying someone did me wrong, and I think I should be owed a certain amount of money. So please, would you make this person give me the money? Well, and the defense actually pleads also. What they plead is, please find that this person isn't owed a cent because I didn't do anything wrong. Please find that out for us, please, and give us justice. So that's a pleading also. So the pleadings are things that set the issues that will be tried in the court based on the writings of the plaintiff and the defendant in the action. So again, when you see the word pleading, think of it as where we are setting out the reasons why people are in the court in the first place and all the issues that they want to have adjudicated by the court. All right, so it gives notice to the parties, and this is a pleading like a complaint. It gives notice to the parties of the issues that are complained of and the issues for defending against the complaint, both. So when we have a pleading, it's both a complaint and the answer by the defendant that are considered pleadings because both of them are asking for certain relief from the court, even if the relief is simply to say that the person isn't owed any money at all. And also this allows parties to prepare for their cases for trial because if there isn't a defense that's pled in the response by the defendant, we don't have to prepare for that defense coming up at trial because it's not in the pleadings. If it's not in the pleadings, it doesn't get into the trial. These things are the outline of what will be in the trial, and you are not going to be able to change those things absent permission from the court and having a good reason why you didn't have them there in the first place. Okay, California courts require what are called fact pleading, so that you have to allege facts that must demonstrate all of the elements of the cause of action that you are going after. So if you had a breach of contract cause of action, you'd have to plead facts that show that you have a contract, an enforceable contract. You'd have to plead facts indicating that the other side created a material breach of that contract. And then you'd have to plead facts that indicate that you have suffered damages as a result. If you don't plead all those facts, you will not have a cause of action, and your case will be kicked out of court if you happen to file it without having those facts that do so. Federal courts only require what's called notice pleading. And that's simply a short and plain statement of the claim showing some sort of right to relief. So you could say, you know what, we have a breach of contract against Joe Smith, and it happened around this particular time, and that's it. That's all you have to do. And that, they think, is sufficient notice that the other side should know what's going on. California requires more. It requires that you actually plead facts that meet all the requirements of the cause of action. And in federal courts, you just have to plead that there is a cause of action, and you're good enough. All right, let's look at the parts of the complaint. First is the caption. That's simply where we name the parties. We have up at the top the name of the attorney who's filing the complaint, or if it's in pro per, it's the name of the plaintiff and their address and so on, the contact information. And then we have, of course, the parties, the plaintiff versus the defendant. And then on the right-hand side of the caption, we have the case number, the title of the document itself, which is obviously a complaint for something. And then we have the body of the complaint, which is allegations of what the person is complaining of. In federal court, it requires first that you have what are called jurisdictional allegations, because you can't get into federal court unless you can prove that the federal court has jurisdiction over your case, and you have to prove that up by factual proof. In essence, you have to prove facts that indicate that the court has jurisdiction, and if you don't, then they'll dismiss your case because they don't have jurisdiction. Or you have to prove that they have jurisdiction. They don't have to assume that you do. You have to prove it. That's not true in state court because state courts are courts of general jurisdiction, and so long as you can say that something happened in California or something should have happened in California, then you have sufficient jurisdiction in California. And so then we have general allegations that are allegations of who the parties are, who they are to each other, what kind of transactions may have been involved, and then we have specific allegations for each cause of action. Again, you may have a single transaction, a single event that happens that could end up being 15 different causes of action. It's possible 15 different laws could have been implicated in a single incident, and so you would allege each one of those, and in California you'd have to but you have to allege facts that would that if were true would substantiate each of those causes of action. Then, of course, you have a prayer for relief. You say, okay, now I've all these causes of action. and we've suffered damages and so on. I want you know, a certain number of dollars according to the proof that I put on at trial. You're not, in fact, in California, you're not even allowed to put in the amount that you're asking for anymore, because there was a lot of problem with people claiming $1 billion in damages, and the press would pick that up and make a big deal out of someone asking for $1 billion. Well, you can ask all day for $1 billion. That doesn't mean you're going to get it. It doesn't mean anything. It's just an allegation. So now they say that you have to pray for an amount of damages subject to proof at time of trial, just to get around the fact that people were abusing this prayer for relief and, you know, sending it to the news media to make a big deal out of something that wasn't a big deal at all. Then there's a subscription, which means a place to sign. It's signed by the attorney if it's represented by an attorney, and it can possibly be verified. And usually we don't do that, but you can verify it. That means you can say, under penalty of perjury, everything in this complaint are true. Got to watch out for that, because it may be that what you're saying in your complaint is not true. It's just you think it's true. But if you state that it is true, you better be absolutely certain that it is. Otherwise, you have to allege it under information and belief that you believe it's true. That's safer than to say that it is true, because if it isn't, you could be put up for perjury for saying something's true that is not true. Okay. Now, when we actually file the complaint, we also have the court issue a summons. A summons is simply a notice from the court that says you're being sued. This is an official action. You have a certain limited time in which to respond to this complaint. If you don't, a default judgment will be entered against you. It's actually stamped by the court with the court's official stamp, so that people will see that it's an official document. And it says who's being sued, by whom. It doesn't say what you're being sued for, but it says that a copy of the complaint is attached. So if you want to know what you're being sued for, here it is. But this is summoning you into court, giving you a chance to defend yourself. It's essentially what it means. If you don't come in and defend yourself, then you will end up having the default judgment against you. We don't care that the complaint might not be true. We don't care. If you don't defend yourself, you're going to end up having a default judgment against you. So what has to be done with this summons and complaint is it has to be generally personally served, hand-delivered to the person who is being sued. The reason for that is that we have a requirement of due process, which is a constitutional concept that we don't allow people to be sued or criminal cases to take place without notice to the person who is being sued. If you're being sued, you're entitled to notice of that. Well, it's such an important right that we want to make sure that people actually get that notice. Not like they should have gotten it, or we sent it to them in the mail, but no, they never got it. That kind of thing. No, we want to hand it to them right there and say, this stuff means you're being sued. Here it is. Hand delivery. That's what we call personal service. And that's the best kind of service. In fact, it's sometimes the only way you're going to do it. But there are times where we do allow substituted service. If we've done a lot of diligent attempts, we can substitute service if we can give it to someone, let's say, who's an adult who lives at the person's house and who accepts it for them, like a person's wife, for instance. You're suing a man and you can't find him because he's never home, but we know he's around, but we don't know when he's there. So we just say, all right, we've come here 20 times, but you know what? We're going to give it to you, ma'am, if that's all right. If you'll please give it to him. That might be sufficient service, possibly. You can also do service by mail, but it requires an acknowledgement of receipt, where they have to send back saying, yes, I know. Thank you for the summons. I'll acknowledge that I've received the summons complaint. So they acknowledge the fact that they have received it. That's good enough. And then if we can't find the person and we can't serve them personally, we can't do substitute service, we don't know where they are. We've done diligent attempts both to find them and have come up dry. And we've done sufficiently diligent attempts that the court says, okay, you know what? We're not going to easily find this person, so I'll tell you what, we're going to serve it by publication. We're going to make you put it in a newspaper for 30 days, once a week. It's going to be published. And you'll actually see this if you go in your newspaper. You'll see summonses being published, and it's someone who they can't find. And it says, you're being sued, so you better come on in. And if the person doesn't come in the proper time, then they can get a default judgment against them. Because of service of publication, we know it doesn't always get to them and often doesn't. We usually allow them to set aside the default later on if it's within a reasonable period of time, just because of the fact that we know it's never probably going to get to them. All right, then there's a return of summons. That means once you have served the summons, you have to return it to the court with a proof of service document that says, okay, this summons was served by hand delivery on the person being sued on such and such a date with hand-to-hand service at such and such place, and has a signature of the person who is a person over 18 years of age, not a party to the action, who has served the summons on the person. Now, when it comes to service of the summons and the complaint, there was a lot of times where people would file complaints and then never serve them. They were doing that because they wanted to stop a statute of limitations from running against them, but they didn't want to serve it because they didn't know whether they really wanted to sue the person. Courts didn't like that because they were end up with just a whole bunch of complaints that had never been adjudicated, just sitting there doing nothing. So they made up a new rule, a new court rule. This has been probably in the last 20 years. That says that you have 60 days from the filing of your complaint to serve that summons. And if you haven't returned the summons within those 60 days, then they're going to, the court will file what's called an ex parte motion. If you don't file an ex parte motion to extend it before the end of 60 days and show good reasons why you need more time, then they can dismiss your case, which can be devastating because it could be their statute of limitations has already run. And if that happens and you dismiss the case, you can never refile it. So it could be very, very damaging. So these are things you have to be watching out for. By the way, that is one of the deadlines you want to put on your list, is you have to serve the summons and complaint within 60 days of filing the complaint. That's one of your first deadlines that you have that you'd like to see on your list of deadlines that you will want to know for your quizzes. All right. Okay, very good. This is the end of Chapter 1 for right now. It's the end of the complaint and service of summons and complaint. If you have any questions, again, please feel free to give me a call.